I welcome you in 12th lecture relating to legal compliance for incorporating startup. I was in the module called Incorporation of one person company, private limited and public limited company. Now in this particular module I'll concentrate more on law relating to private limited company. Now yesterday I had talked with you one person company, and I have told you that this one person company is also a private limited company, but one person company has certain different feature than that of a private limited company. To put it in other way around, in case of the one person company, the compliance requirement is lesser even than of a private limited company. So private limited company's compliance is more than a one person company, and at the same time this is also a formal structure or formal organizational setup, and you are required to comply number of provisions under the Companies Act. But please do remember that even in case of the private limited company, the compliance requirement is lesser than public limited company, and in my subsequent lecture I will going to deal with the law relating to public limited company. Now before I go further, let me draw your attention about certain specific characteristic of a private limited company, and which is a distinguishing factor from a public limited company. Now in case of a private limited company, you need to have a minimum paid up capital. Now paid up capital means which you need to raise during the time of incorporation. That means at the time of the incorporation you need to specify that what should be the capital of the company with which you are incorporating, and how much capital are subscribed by those people who are participating in the incorporation of the company. That means who are basically the promoter initially, and once the company incorporated, they became the member of the company. Now previously under the previous act, CA 1956, that means 1956, Companies Act 1956, the minimum requirement for a private company was 1 lakh of rupees, but you will find there is a recent amendment, and in that particular amendment that specific requirement is withdrawn, and it has said that whatever has been specified. So now the ministry kept it open for a different specification to be prescribed at different point of time, so that it can adjust the structure of the company based on its industrial policy, or wherever it will prescribe that a particular type of organization one should float for the purpose of entering into a particular segment of the industry. Similarly, in case of the private limited company, there is a restriction on transfer of the shares, which you will find quite unique with the private limited company, and this is not so in case of public limited company. So we put it we can also mention in this particular juncture that this is also known as a preemptory right. That means whoever is a member of the private limited company, you need to offer them first before you transfer this share to the other person who is not an existing member of a private limited company. So in case of a private limited company, there can be a restriction of the shares, and you can have a specific provision in what circumstances the share can be transferred. At the same time, the law also prescribes so that you cannot transfer the share outside the existing member unless there is a certain condition prevail or you qualify certain conditions. Now it is also prescribed the limit of number of members. It says that you cannot have more than 200 members. Now, under the previous act it was a 50, that means under Companies Act 1956 the maximum number of member of a private company was 50, but under the present act it is increased up to 200. But herein you should remember that if the two person is holding the same share or two person is holding jointly a same share, then in that case for the purpose of this law they will be treated as a one person. So, when you are counting the number, if one share is held by two person, then that particular share for the purpose of counting the number of member, it will be only one. Now, if any person who is in employment of the company or was in employment with the company and continued as a member, then for the purpose of counting the total number or maximum number, they will not be counted. So, employee of a private limited company who is a member of the company, they will not be counted as a member of the company. Now, at the same time, the private limited company cannot invite public to subscribe its security. Now, there is some exception has been made to it, and I am going to describe this particular thing in detail under this particular present act in the subsequent part of my lecture. Now, a private company, to incorporate a private company, you need at least 2 person, or there can be more than 2 person to incorporate a private limited company. Now, in case of the private limited company, you should specify the word private limited at the end of the name of the company. So, that means to identify a company or to easily identify the company's name should tagged with the word private limited. Now, again again that if the company incorporated with a charitable objective, then in that case this word private limited can be dropped from the name of the company. Now, as I have discussed with you, in case of one man company, similarly a private limited company can be 3 types. That means, it can be limited by shares, it can be limited by guarantee, and it can be unlimited. Now, when we are talking about the shares, the liability of the member is limited up to their contribution in the share capital of the company. So, for example, if somebody subscribe 10,000 shares of a company, then in that case his liability is limited up to the 10,000 shares, and the value of the 10,000 shares might be 10 into 10,000. So, that is his liability in terms of monetary value. Now, when we are talking about the guarantee, it means that if the company incur any losses during the carrying of his business, then in that circumstances the member of the company may extend a particular amount of guarantee to the loss of this particular company in addition to the share contribution. So, at the time of the incorporation, the member might say that they are ready to take the guarantee of 10,000 rupees. So, in the circumstances, if the company is unable to make the liability or the losses, then in that case the member will further contribute the 10,000 rupees towards the liability of the company. Now, there can be a private limited company which is unlimited. That means, the member will have a unlimited liability. In that circumstances, the member will have a joint and a several liability. That means, members not only liable to the date of the company, but the assets of the member may be utilized for making good the debt of this company. That means, company has to pay whatever the debt it has, and if he is unable to fulfill all the losses or the debt to its creditor, then member will pay it from their own assets. So, this kind of a company can be incorporated. If you look into the normal conditions or the majority of the company, then you will find majority of the companies are limited by shares. There is a very few unlimited companies are there. At the same time, there is also very few companies are there which are limited by the guarantee. There is also a possibility that company can be incorporated with limited by shares as well as a guarantee. And if you look into the Companies Act, you will find there is a specific style of memorandum of association and article of the association provided for this kind of company with a limited liability as well as limited by guarantee. Now, let me take you to next aspect relating to the incorporation formality. I am going to deal with this particular incorporation formality in the subsequent lectures in detail, but nevertheless, which I have indicated also in one person company, let me do it for this private company too. And you will find that these formalities are almost similar in case of one person company, private limited company as well as public limited company. So, in case of a private limited company, the first important thing is that to find out the name of the company, because it might so happen you want a particular name of your company or your startup, and that particular name might not be available for the incorporation of your startup, because according to the law, the name which you are choosing, it should not be deceptively similar with existing business name, trade name or name of the company or name of any other organization. So, that means generally you will find the business identify by the name, and in that circumstances people those who are contacting with you, they should not be at any circumstances misled by the name of your startup or your private company. Like there is a name of the company is Infosys. So, the moment we use the word Infosys, we indicate a particular company or particular band. But if you write something like Infosys Systemic Company Limited, then by adding this systemic, you might not get that particular name, because it might be a confusion in the mind of the people that is it a Infosys subsidiary or are you related with Infosys. So, it will be discouraged not to take that kind of a name. So, you will find that now this particular process is made quite easy. You can simply go to MCA website and then you can click on the link relating to finding of the name, and then you can write the name on the box and then search that particular name is available for you to choose for registration or not. Now, whatever the condition is, in case of choosing the name, you are required to give 3 name or more than 3 name while you are applying for getting the name from the registrar, and it generally takes some time when the registrar of the company is going to grant them this particular name to you. So, choosing the name for your company is one of the important process. Then you need to decide that what should be the register office of your company. That means where people should communicate with your company or in which address people should communicate. And the register office is important from the many aspect, because many law applies based on your position of the register office. like you might be subjected to particular type of taxes, you might be subjected to particular type of operation of law relating to accessing the capital, you might be subjected to the litigation because of your based on your situation of the register office. Then you might need to hold your general meeting where your register office is. So register office is a very important issue again. So you need to find out or settle down this particular register office issue. Now this is important to mention here. If you want to move your register office from one place to another place within a district, then in that case you need to notify that particular thing to the register. If you wanted to move within a state, again then you have to call your general meeting to put this particular matter before them and to take adequate consent from them. And if you want to move from one state to another state, then in that case you need to have a general meeting. At the same time, you need to notify both the registers. That means the register from where you are moving and the register where you are going. Now, I believe who is a register, I have explained to you in my last lecture. Register means register of the companies, and register of the companies is appointed by the central government. So, register, after looking into the general meeting consent, they might give you this particular permission to move from one place to another place. So, register office is one of the important thing, and you need to mention this register office in the constitutional document or formation document of the company, which is popularly known as Memorandum of Association or Article of Association. Now, in case of a private limited company, you need to decide your authorized capital. Now, authorized capital you need to mention in the Memorandum of Association, and authorized capital is such which company can raise in its lifetime until it has been changed by the general meeting. That means, if you are registering a company with a 2 lakh of rupees authorized capital, then in that case company can raise maximum 2 lakhs as a authorized capital. Now, this is also important to note that as much your authorized capital will be, whenever you are doing the registration of your company, you need to pay that much of registration fee. So, it is always advisable that you should not over capitalize. That means, you should not put a very big figure in your authorized capital. At the same time, you should not show less authorized capital in your capital clause, that you need to go for amendment very quickly, because amending the authorized capital is a quite tedious job. Now, as I have discussed with you, in case of a 1% company, this is also important here, that for private limited company too, you need to have a memorandum of association and article of the association. Now, I have told you that in memorandum of association, most important part is that it includes the objective clause. That means, on which of the subject the company can carry out the business, whereas in case of the article of the association, you basically provide what are the matter the company need to handle for the internal management. I will detail out this particular 2 document in my subsequent lecture. Now, once you complete all these particular formalities, you put all this particular document to the register of the company. It can be done online, or you can take the help of a professionals who will deposit the AOA, will deposit that who are the people who are going to be a director of this particular company, is if there is any further compliance is required in that particular sector, that particular certificate, and all these things need to be certified by either advocate or chartered accountant or company secretary, and then you can submit this particular document to the register for the verification. Now, once the register will scrutinize this particular document and satisfied that all the matter has been complied with, register is going to issue a certificate, incorporation certificate. And please do remember, this incorporation certificate is a birth certificate of the company. So, whenever you are going to refer any of the regulatory issues, you need to refer this particular date of incorporation, because this is one of the very important date which you need to always keep it right, and you need to preserve the incorporation certificate properly in your register office of the company. Now, there is a certain statutory provision I thought that it is important that you should know. If it is if there is a subsidiary of if the private company is a subsidiary of a public company, then it will be deemed as a public company. Reason is, whatever the money which has been infused in a subsidiary company by the public company is basically the public money, because public company generally raise the public money through the public placement or the private placement, and that's the reason it has been law has been law has been drafted like this. The subsidiary of a private company is a deemed public company. Now, a private company has also right, as I have talked about talked with you before, that they can incorporate the restriction relating to the transfer of the share. At the same time, the statute also give this condition in the statute itself, that you can impose a restriction relating to transfer of the share in case of a private company. Now, in generally, the private company is only allowed to raise the capital from its own member. So, the private company can issue the right shares as well as the bonus shares to its existing member. But under this present Companies Act, that is CA 2013, Companies Act 2013, they have incorporated a specific provision called a private placement. Now, the private company can also participate or raise the capital through the private placement. And the private placement means the security has been invited a selected group of person by a company other than by way of public offer through the issue of the private placement offer letter, which satisfy the condition specified in this particular section. That means the section which is, or the provision which is dealing with the private placement. So, to put it in another way around, if your company have a clientage, that means number of people who basically purchase your product, or there might be a suppliers, or there might be a creditors of your company or your startup, then you can also ask them to subscribe the shares, or you can issue the shares to these particular people. So, these are the target group of people. Or it might so happen that if you are taking a professional service, like you have a chartered accountant for looking after your accounts, or you have a lawyer to look after your legal issues, then you might even ask him to contact his clients who might be interested to subscribe the shares of your company. So, this is basically, to put it another way around, called a private placement. Now, let me talk relating to the compliance and annual general meeting in case of a private company. And you will, as I have told in the beginning itself, the compliance requirement in case of a private limited company is little higher than 1% company, and for that matter general meeting too. So, every company need to file annual return as well as the financial statement signed by the directors in every end of every financial year. And there is a several matter which you need to state in the annual report itself, which includes the directors report, which include the ownership pattern, which include the disclosure relating to the different issues, at the same time which also talks about the profit and loss account of that particular company, for that matter the financial health of the company. Now, this disclosure requirement in case of a private company is not as stringent as in case of a public company. I am going to speak more when I will talk with you relating to the public company, but for that matter, the private company's disclosure is more than 1% company, but in case of a private company, a public company, it is much more than this. Now again, you need to hold a general meeting, and in every general meeting, every general meeting need to be hold within 9 a.m. to 6 p.m. in any day which is not a holiday, national holiday, and where and it should be in the same place where the register office of the company is. Now in the annual general meeting, there is certain specific thing you should keep in the mind. That means for the annual general meeting, you should have to give a notice for clear 21 days, and in the notice you need to specify that what are the business which you are going to transact in the annual general meeting. Statutorily, there is a couple of business which is specified, like appointment of the auditor, appointment of the directors, then considering the financial report of the company, and if there is any other matter which is which is called as a special matter to be listed into that particular notice itself. Now there should be a quorum of the meeting, and you can specify what should be the quorum in the meeting in your AOA. At the same time, you will find the law also provide the quorum for the meeting. So it is whoever is present, and they basically form the quorum of that particular meeting itself. Now in case of the chairman, generally the person who are present, one of them can be appointed as a chairman, but nowadays you will find the chairmen are generally a designation which company always carry. Now the same chairman who is a chairman of the board, or somebody is appointed as a chairman of the company who chairs a board meeting as well as he chairs a meeting of annual general meeting. And both the cases, it is recommended that the person should not be an executive director of that particular company, but it should be a non-executive director. These provisions are quite stringent in case of a public limited company, but not so in case of private limited company. Now in general meeting, the people can be represented by the proxies. That means the shareholders can be represented by the proxies. Proxies means that you are authorizing another person to go and attend the meeting on your behalf, but there is a certain restriction relating to the voting by the proxies. Similarly, now there is a change relating to the casting of the vote. Now you can cast the vote through the postal ballot. That means, or any electronic medium. Now postal ballot means it can also any electronic medium. That means through the website also you can cast the vote, but there should be some kind of authentication procedure, and you have to follow that. Now there is a provision relating to the board. In case of a private limited company, there should be 2 members in the board. Private limited company need to hold the first meeting within the 30 days from the date of incorporation, and then hold the meeting in every 3 months. That means there should be 4 meetings in a year. Now a meeting of the board shall be called by giving not less than 7 days notice, and a private company may by its own article provide the additional ground of vacating the office. Now let me tell you this particular thing. In generally, the law provide a long list relating to vacating office by the director as well as the qualification of the director. Now qualification as well as vacation of the office are same for all those companies, either it's a 1% company or a private limited company or public limited company. But in case of the private limited company, it is most of the time overlooked, and only in very acute conditions you generally apply this particular thing. So if you are become insolvent, or you are become a insane, or if you are adjudged as an insolvent, or you have done some kind of offenses under the criminal law, then in that case you are disqualified. Similarly, if you are failed to pay the dividend, or if you have not complied with the regulatory laws, then in that case also you are disqualified. But in addition to that, the private company can specify further ground for the disqualification of the director. This is a quite a specific provisions for the private company. Now, there is a power of the board. In generally, the power of the board are same as the company, which you prescribe in the objective clause of the company. Then you can have a restriction on the power, like in the matter of the restructuring, matter of the raising the further capital, matter of alienating the property of this particular company. There can be kind of restriction for this particular purpose. Now, there is a new provision which is created called a related party transaction. That means if there is any person is interested in the company, and because of that there is a particular transaction is happening, then in that case that detail of that particular transaction need to be placed before the board, and board has to take a critical look into this thing before they sanction this particular transaction. So, related party is one of the very strong provision which has been incorporated under this particular law, and some people say that it really creating a difficulty for many transactions in India, because in India generally the ownership is family based, and most of the time whatever the definition has been provided related party, most of the transaction cannot go through because of this closed knit holding system, ownership system in India. Now, if you are using the word private limited for the improper manner, or where you are not a private limited company but still you are using this word private limited, you are subjected to punishment, and there is a certain provision has been created to that. Now, it is important to draw your attention here that you can do a lot of conversion. You can do the conversion from a private limited company to the other organization, and I have told you when I have started the first introductory lecture that it is always good that you choose a simplest form of the business form, and then you later on can go for more formal structure. So, you can convert the LLP into a private limited company, and there is a procedure has been provided in LLP Act itself. You can convert the private limited company again to LLP, and that is again procedure has been provided in LLP Act itself, that means Limited Liability Partnership Act itself. And in both the cases you need to restructure the constitutional document. That means in case of conversion to LLP, you need to create a document which is the incorporation document or the formation document, whereas the moment you are converting it from LLP to the private limited company, again you need to create the EOA and MOA, and then there is a particular process through which you can transfer the assets and liabilities, and the moment it is done, then the organization which is been transferring it become defunct, and you can strike it off this particular organization. Similarly, a private company can be converted into a public company, and public company can be converted into a private company, and these particular conversion govern under the Companies Act itself, and there is a clear provision has been provided relating to this particular thing. Now, company can be amalgamated. That means two private company can go for amalgamation. To put it in a popular term, that means they can go for a merger, they can go for a spin-off, and there is a most of the time you will find whenever the company is stressed or company is not doing well, they can get merged, or if the company is unable to really do well, then the company can go for winding up. That means you can liquidate the company's asset and you can distribute the assets of the company to those people who have promoted the company as a startup, and then you can also pay back all the debt which the company has incurred during its business. Thank you.